Good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause, and then we will talk about release conditions. Please note that today is not an adversarial hearing date. It's not your trial date. And so I encourage you not to talk about your case on the record unless you've spoken with your attorney, because everything in this courtroom is being recorded, can be used against you at a later time. If you wish to speak, if you are represented by the Public Defender's Office, those attorneys are available to you. I do have one attorney in the courtroom with me, and then another attorney over at the main jail. At the other facilities, these attorneys are available to you by phone. If you are represented by a private counsel, those attorneys will come to the courtroom and are able to address your case. If your attorney's not here, you can let me know, and we will see how we can facilitate you through that process. Please don't tell us that you have private counsel if you or your family did not retain an attorney for this arrest over the last 24 hours. You also need to know that in the courtroom with me, I have attorneys from the state attorney's office, as well as representatives from the confinement status, pretrial supervision, and the clerk of courts. And these persons are here to help to facilitate the morning's process. They are able to give additional information if needed. After today, your case will be assigned to a division judge, and then moving forward, any substantive hearings, motions will be filed before that judge. Okay? We will start this morning with Paula Barrows.
North Broward, Your Honor. Good morning.
All right, good morning, Deputy. All right, Ms. Barrows, good morning, ma'am.
Good morning.
You are before the court today because you have one charge of battery on a person 65 years or older. I find probable cause. Does Ms. Barrows have any prior criminal history?
She indicated to me that she does not, Your Honor.
Okay,
She does live with her brother, who is the alleged victim in the case, who's 1 year older than she is. But she believes that he will be able to live with her brother-in-law. But at this point in time, she does have her phone and property, but she hasn't been able to access it. She's been a resident of Florida since 1966, which is even longer than I've been a resident of Florida. And I know that there is some very concerning language in the probable cause affidavit. I've spoken with Ms. Burrows. She indicates to me that she's okay, that she's not having any bad thoughts at this point in time. I was going to ask the court to consider releasing Ms. Burrows to pretrial release.
all right. Having no priors, I will release Ms. Barrows to pretrial supervision. Ms. Barrows, what that means is the deputy is going to give you a sheet for the pretrial office. Instead of you posting a bond, you'll be released and be on pretrial supervision. Today is Friday, and they're not open over the weekend. So that means no later than Monday morning, you need to show up at that office, ma'am, and sign up. Do you
I don't have
understand? You don't have your what?
my glasses on.
All right, when you have your glasses, you'll be able to see the address. I'm just telling you that by Monday morning, you need to show up it's downtown Fort Lauderdale, close to the courthouse, behind the main jail, in that area, okay? And no victim contact, all right? So what that means is no phone calls, no text messages, no social media, no third-party contact. Now, I know that you live at the house, so is there anyone that can go pick up your personal items?
I have a puppy, I have
My question is there anyone
Yeah.
who can go pick up your items for you?
Actually, from what Ms. Burrows has told me, Judge, I believe that her brother is going to be the one to vacate the premises. They
Wow.
share the house that previously was owned by their mother, and they're in the Did you say you were in the process of selling the house, Ms. Burrows?
yes, the whole family owns the property except my brother.
Here's the thing, I have no control over your brother,
I
okay?
understand.
My only authority is over you. So at this time, I'm telling you that you cannot have contact with your brother. And if you need to pick up items from the home, either I can grant you one time with law enforcement to go pick up the stuff, or you can get someone else to go pick up the stuff for you. That's all I'm saying at this time, okay?
Okay,
Good luck, Paula. Take care.
okay, thank you.
All right, Maria Cardozo,
North Broward County, she's gonna require a Spanish interpreter, please.
all right, so we'll recall when the Spanish interpreter is here. All right, Alvanica White,
She's a medical reset. She's gonna call you when the Spanish interpreter
all right,
comes.
Miss White is a medical reset. Caroline Norgate, is that a medical loan as well? All right, Norgate is on medical loan. Yes. Heather Amari,
She's a medical reset also.
okay. So Amari is a medical reset.
Wait,
Jessica Cover,
North Broward.
Ms. Cover bonded? All right, ma'am, you are before the court on 2 counts of touch or strike battery and 1 charge of disorderly intoxication. I find probable cause, and I've been advised that your bond has been posted.
Gotcha.
Okay?
Please stay out of trouble, Jessica.
Judge, I would just also ask. if
No
you-
victim
No victim
contact.
contact. Thank you very
Okay.
much, Judge.
Ma'am, no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, ma'am?
I don't even know who this person is, so
Well,
sure.
well,
No need to say anything about the facts of the case, Jessica.
Yes,
there are 2 persons involved, no victim contact. Do you understand that?
yes, ma'am.
Okay. Tammy Lee Parent,
She's approaching, Judge. She's here at me.
ma'am, you are before the court, charge 1, burglary, unoccupied dwelling unarmed. Number 2 is petty theft. 3, 4, 5, 6 are burglary, unoccupied dwelling unarmed. 7, 8, 9, 10 are petty theft charges, and I find probable cause for all those charges. Does Ms. Parent, does she have any prior criminal history?
Your Honor, she does not have any prior criminal history that I can see. State would be asking for a $1,000 bond on counts 1, 3, 4, 5, and 6, and leave the standard bond amounts for the remaining misdemeanor charges. And no return to the location of incident at 6300 Funston Street in Hollywood, Florida.
Okay,
I didn't see anything. You have priors?
Judge, in speaking with Miss Parent, unfortunately, when I told her what she was facing, what's before the court this morning, she doesn't know anything about it, doesn't know anything about the incident date, doesn't know anything about the location, doesn't know anything about the particulars of the case. Having said that, I did tell her that today is not her trial date. Now, my understanding, she's been residing here in South Florida her whole entire life. She's self-employed. She does cleaning, but unfortunately, the last time she got paid was about 2 days ago, $25. She's homeless. She's financially indigent. She cannot afford any sort of monetary bond. Now, she's looking forward to having her day in court to actually learning and finding out facts about this case because she doesn't know anything about it. But she told me that she has no one to call or no one to contact. So, Judge, I'm asking you to take that into consideration determining reasonable release conditions for Ms. Tammy Parent.
all right, so
And in all,
this incident date per the allegations, August 6th was, I guess, was when law enforcement was contacted. There were several times that this residence was entered, July 27th, July 29th, July 30th, August 5th, and August 6th by video, and video was provided, all right?
Judge, I'm also going to just make the court aware, apparently I was looking up the wrong defendant. She does have criminal history going as far back as 2004. She does have an unlawful use of false name, which she received a withhold, petty theft adjudication in 2016, a petty theft shoplift adjudication in 2007, and a grand theft withhold with a VOP from 2004, plus some other traffic criminals as well.
And I feel compelled to point out that this probable cause affidavit is really devoid of an awful lot of facts. It doesn't say which, there's allegedly 6 different occasions where Ms. Parent is accused of going into the same house, which, that I find somewhat troubling. But those dates aren't mentioned. So I don't think the court can even find probable cause
Those
because
dates
no
are
dates.
mentioned. Those
The
dates are mentioned at the last line.
the last
July
line of the piece.
27th,
Oh,
July
you're right,
29th.
you're right. You're right, Judge, my mistake, I'm sorry.
They're all there.
But it's still very vague as to what was taken. Cigarettes, kitchenware, etc. It is not probable cause to determine a petty theft on these charges. There's an awful lot of information that is completely absent from this probable cause affidavit. So it asks the court to take that. I'm not saying that the court can't find probable cause, but I think that what's been presented to the court here this morning certainly is something the court can take into consideration.
All right, I am going to impose $1,000 bond on 1, 3, 4, 5, and 6. The other standard bonds will remain in place. No victim contact and no return to that location. Gina Marino,
Jeff Brown.
Ms. Marino bonded. All right, Ms. Marino, you're before the court for 1 charge of grand theft. I find probable cause, and I've been advised that your bond has been posted, okay?
Judge, I would also ask that you instruct the defendant not to return to the target location at 3200 North Federal Highway.
Yes,
You heard that, ma'am? No return to that location?
yes,
All right,
I heard.
all right. Ms. Jackson,
All right, come on.
Chrisith Jackson,
She's here, present, Judge O'May.
all right, Ms. Jackson is before the court. Charge 1 is grand theft auto. Number 2 is driving while license suspended. 3 and 4 are felony violation of probation with a no bond hold. And Ms. Jackson will see, it looks like Judge Fine on September 9th at 8:30 a.m. in regards to the VOPs. I find probable cause, and I'll leave the standard bonds in place on 1 and 2.
Your Honor, I've been advised by the main jail that there are some individuals that they would like called out of order.
Okay, who are those?
On page 8 of the court's docket, Mr. Burley,
Mr. Burley, come on up, please.
Burleigh.
Okay, hold on.
On the following page, Purnell Shingles. On page
Okay,
16,
Did we pull out Burley? No? Yeah, go back again, I don't see Burley, hold on.
it's spelled
All right, got it.
Burleigh.
And then after Burley's who?
Shingles,
Okay,
he's on the next page, page 9.
okay,
The third gentleman is Mr. Ryan Jazzo, Jazo. He's on page 16 of the court's docket. Thank you, Ed. And very close to the end of the court's docket, in fact, just a couple of cases from the end, is Jermaine Shenett, Shenett.
all right, then, Jorge Burley, or George Burley.
He's here, present, Judge.
All right, Mr. Burley's before the court. These are for add charges 5, 6, and 7, which are out-of-state felony holds. These are out of the state of Texas, and these are no bond holds, and you will be going before the extradition court next week. And then Purnell Shingles.
Mr. Shingles is approaching, Judge. He's here at Maine. Come on up, Mr. Shingles.
All right, Mr. Shingles is before the court on one charge of resisting officer without violence,
Can I have her call you back just in case?
and I find probable cause.
Judge, in speaking with Mr. Shingles, he wishes to resolve this matter today. We're seeing if the state has a plea offer.
Okay,
Your Honor, state would have no problem with adjudication time served at this point.
okay.
Okay, and your name
He
is?
wishes to accept the state's offer, Judge.
All right, Mr. Shingles, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. And do you understand the offer that has been extended to you, sir?
Yes, sir. Yes,
Is anyone forcing you to resolve your case?
no, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served, okay? Ryan Jazzo,
Mr. Jazzo is approaching, Judge. He is page 16 of the docket.
all right, Mr. Jazzo is before the court. Charge one is resisting officer with violence. Number two is trespassing, failing to leave property upon order by owner. I find probable cause. And I'll hear from the parties as to bond.
Judge, Mr. Jazzo advised me he's financially indigent. He's homeless. He's currently unemployed, but he's looking for work. There's no one he can contact to help post his monetary bond. He did advise me he will be coming back to court. So, Judge, considering he's financially indigent, we're asking if the court would consider releasing him on pretrial release.
Are there any mental health issues?
Not that I'm aware of, Judge.
Okay,
He does have a 2019 trespass. He received a withhold and time served.
okay.
So I'll defer to the court with regards to pretrial release if they would otherwise take him.
All right. All right, Mr. Jazzo, I'll release you to pretrial supervision. Sir, you must report to the pretrial office by Monday morning. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
This is a new charge.
No, that means you'll be here. Okay. You understand? Tell the judge you understand.
All right, and also, what is this location?
It seems to be, looks like it's a bar. I think it's called Rattlesnake Jake's, Judge.
Right,
at,
and so, sir,
2060.
no return to Rattlesnake Jake, bar, okay?
Yes. And if you get released early enough today, then you go today, okay? Because they close, I think, at around 4 o'clock. So you go today if you Friday? Yeah, today's fine. They're across the street, okay? Good-
All right,
thank you,
good
Judge.
luck, sir. Jermaine Shennett.
He's approaching, Judge. He's here at Maine.
All right, so Mr. Shennett is before the court for throwing a missile into a dwelling, vehicle, or building, and I find probable cause. And does Mr. Shennett have any prior criminal history?
Judge, if you can just give me 1 second, I need to look up an additional case.
Okay. And are there any mental health concerns?
It's theirs today or tomorrow, I'm not sure.
The allegations are throwing rocks at vehicles.
Yes, Judge. Judge, it looks like defendant is also on pretrial release or bond on a case before Judge Weeks in case number 19001430CF10A. Looks like it is also for throwing a missile into a dwelling, vehicle, building, or aircraft. Looks like the court found PC on that case, and he was given a $7,500 bond. I'm just confirming, doesn't look like it's the same address or victims, Judge, but it is the same crime. He also has priors dating back to 98, most recently a trespass in 2018 adjudication, violation of domestic violence adjudication 2018. There was unlawful use of false name in 2016 adjudication, fleeing and eluding adjudication in 2013, resisting without violence 2011 adjudication, resisting without battery, possession of cocaine twice, burglary, conveyance unoccupied, attempt burg, conveyance unoccupied, and possession of burglary tools and grand theft, all adjudicated going back as far as 2003. There's also tampering, fabricating with evidence in 2003, robbery, no weapon, 2000 adjudication, and a possession of cocaine and resisting without violence adjudication and a VOP as far back as 98.
Okay.
So just based on that, state's recommendation for bond would be $10,000 as to count one.
Well, what was the incident date on the case that he's out on bond on?
It's Friday, December 28th, 2018, Judge.
Okay. All right. I'm not sure what's going on here. Yes,
Judge,
Mr.
thank you for giving me this opportunity and speaking with Mr. Shinet. First off,
I do have not with a firearm, no, but I have like a conviction of a robbery, but not with no firearm. I don't have no violent charges like that.
first, Mr. Shinet wants me to bring to the court's attention, we believe the state mentioned he had a robbery with a weapon. From his understanding, he never got convicted or accused of any sort of robbery with a weapon charge, so he is disputing as far as his prior history relating to that offense. Having said that, Judge, he's been residing in our community his whole entire life. He is 38 years old. He's right now unemployed, but he's looking for work. Now, he did advise me that he's currently has an open charge. He has the Office of the Public Defender assigned to that case. He's been meeting with his attorney, going to court, looking forward to having his day in court on that case and disputing those allegations. What's here before you today? My understanding, Mr. Shinet also wishes to have his day in court in this offense and looks forward to disputing the allegations on the matter that's here before your honor. Having said that, Judge, as you heard, right now he's not working. He has no financial income coming in. He lives with his mom. His mom is retired. His family's not in a position to post any sort of monetary bond. So right now, basically, for all intents and purposes, that's nobody that can help him. So, Judge, we're asking you to take that into consideration, determining reasonable release conditions for Mr. Shinet, and he will be coming to court, Judge.
Judge, I would point out, I did say robbery, no weapon. I didn't say that it was robbery firearm or robbery weapon.
Okay.
But I would also point out, Judge, he's throwing large stones at occupied vehicles, and in the previous incident from the December 2018, he actually threw a large brick through, or at a waste management truck that was in front of his home at the time.
Right, and that's why I go back to my initial question, is there something else going on here? I don't have the answer to that, but, these are similar crimes that are pretty concerning and have cause for concern for the community. He's out on bond for a similar type case. So at this time, I am going to impose a $7,500 bond, and if there needs to be an evaluation of some sort, then I believe that his attorneys will take that up.
We do represent Mr. Shinet on his other case, Judge, and that issue is something that we are very well aware of.
Okay.
I have his mom's phone number here. I have the number for his public defender, and I'll be in touch with both of those individuals at the conclusion of court this morning.
Thank you. All right, Mr. Shade, you have two cases on page 9, Matthew Inverso.
Judge, we're going to also asking Mr. Shinet a photo order as well.
Sure. Matthew Inverso on page 9.
He's approaching, Judge. Right there. Yes, ma'am. City public.
All right, Mr. Inverso, you have, two misdemeanor cases because you did not show up for your arraignment, sir, on August 23rd and August 26th. So you missed two court dates. So those judges issued cases for you, which is why you're in custody at this time. All right? I find probable cause, and what do you want to do with these cases today, sir?
I was, ma'am, I'd like to resolve it. I was supposed to go to, the community courts, and they said they weren't running the buses up north, so I had to wait. I should have been going by now. I'm going home to Philadelphia.
So he was in community court, and so then he doesn't want to complete the community court?
No, I had to go back on Wednesday. But they said they couldn't do it today, yesterday, because they weren't running up north, the buses.
Is it possible
Great
that we
house.
ROR him on these matters and allow him to try to get back in on Wednesday?
All right. Well, so let me tell you, Mr. Inverso, I know you're saying that yesterday you couldn't get the bus, but the
They
time.
wouldn't let me.
I
yeah.
understand, and I'm not questioning you on that, but what I'm going to say to you is that it was before that you were supposed to be in court, all right? And if you are in community court, you are required to comply with all the requirements there, you understand? Which includes showing up, all right?
Yes, ma'am.
All right, so.
I am homeless.
So
I don't
this,
know where to get
I understand, but you've got to get there because you've got cases pending, right? So I will ROR you at this time, and on Wednesday, you need to show up at community court.
Yes, ma'am.
If you don't show up, I know the judge will let me know, and then, of course, you'll be back in this position. Do you understand that?
Yes, ma'am.
All right. So ROR, you'll be released, and then on Wednesday, you need to get to community court.
Yes, ma'am.
Okay.
Thank you.
Tyrone Smith on page 13.
I've been advised he's on loan.
Mr. Smith is on loan.
That's what I've been advised, Judge.
Have a great weekend, Judge.
All right, you too, Mr. Shades. All right. Mr. Romero, you can let me know if George Egner is on page 21, if you'll let me know when he's in the room. Okay,
I will, Judge.
all right.
Does he have a private or his family?
Well, I believe law enforcement is here, so, okay.
Thank you.
All right. Nicole Freitas,
She's here, Judge, at Maine. She's approaching.
all right, ma'am, you are before the court. Charge 1 is defrauding a financial institution. Number 2 is fraud, attempting to use the ID of another person without consent. And numbers 3 and 4 are possession of blank, fictitious, unlawful issued driver's license. Okay? And I find probable cause for all those charges. Does Ms. Freitas have any prior criminal history?
She does not, Your Honor.
All right.
Judge, Ms. Freitas, has been here her whole entire life. She's 21 years old. She is on disability. She just moved into a new location, North Miami, in a trailer. Right now, Judge, she really has no one to help post her monetary bond, so she's asking to be released on pretrial release, and she will be coming back to court.
Judge, and I'm sorry I misspoke. It looks like she does have a pending battery out of Dade County,
Okay.
but no convictions.
All right. Based on these allegations, the allegations which are that she entered a bank and attempted to access a bank account marked with fraudulent transaction use. She had two driver's license with other people's, other person's name. And these are actual victims whose debit cards that was being used. All right, so based on these allegations, I am going to, she has no priors, so I will reduce the bond on one to $1,000, and then I'll leave the other bonds in place. All right, Colleen Pisek.
Judge, can I have a phone order for Ms. Freitas?
Sure. Edward Quiroga.
Mr. Quiroga, come on up, please. He's here. Judge, we're gonna need, I apologize, we're gonna need a Spanish interpreter.
Right,
There's one on their way, Judge.
okay.
Toma asiento, por favor.
All right, John Tapines,
No problem.
okay. All right, Mr. Tapines is before the court. Charge one is trespassing, failure to leave property upon order by owner, and number two is resisting officer without violence, and I find probable cause for these charges. Does Mr. Tapines have any prior criminal history?
Judge, he has a 2018 resisting without violence and a trespass. He received an adjudication for both.
Okay,
I think you might be inclined to try and resolve this matter this morning, Your Honor.
okay,
Judge, if he would like to resolve it, state's offer would be an adjudication time served on both.
okay,
And
Let's do it.
no return to the incident location.
okay.
Okay, don't go anywhere yet.
All right, Mr. Tapines, you wish to accept that offer?
You said it was time served and
Yes.
adjudicated?
Yes, sir.
Yeah, let's do it.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand the offer that has been extended to you today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time, sir?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served.
All right.
George Trodela.
He's approaching, Judge, he's here at me.
All right, Mr. Trodela, you're before the court. Charge one is trespassing, and I find probable cause.
Judge, in speaking with Mr. Trudilla, he wishes to resolve this matter today.
Judge, the defendant does have somewhat lengthy criminal history. If you did want to resolve it today, state's offer would be an adjudication 3 days, Broward County Judge.
What are the nature of the priors?
He has a violation of county ordinances from 2019 adjudication, a 2017 DUI, 2017 failure to pay restaurant adjudication, 2017 battery adjudicated, 2011 petty theft adjudication, 2001 and 96 theft, both adjudicated, theft in 97 adjudication, another theft in 97 adjudication, burglary, conveyance, unoccupied, grand theft, loitering and prowling, all adjudicated from 97. It goes on resisting without, trespass, possession of cannabis, possession of heroin, grand theft auto.
I understand Mr. Trudella has a long history. My understanding in speaking to Mr. Trudella, what he advised me, he's never been arrested for trespass at that location. With the court, he promises not to come back. He advised me it is a CVS. He knows he's not coming back as a result of his plea offer. Would the court consider extending an offer of time served?
Well, the problem is that this probable cause affidavit does say that he even confirms that he's been previously trespassed from this location. So it seems like Mr. Trudella is having problems following orders.
I'm sure he'll obey your order.
I don't know why you'd obey mine and not obey law enforcement, but,
Well, if he doesn't, he's going to appear before you, Judge, and then anything can happen.
but, you know, the allegations here are, you know, that he did produce his identification, and that he did confirm with law enforcement that he was previously trespassed. So just based on these allegations, I will offer him time served, but I'm gonna tell Mr. Trudella that, you know, you are not to go back to that CVS. And if law enforcement tells you not to go back, if CVS tells you not to go back, and now the judge is telling you not to go back, at some point in time, you've got to stop and realize that you got to listen to somebody. Do you understand that, sir?
Yes, Your Honor.
All right. So, if you wish to accept the time served offer, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, you can put your hand down. And, Mr. Trudella, do you understand everything that we've discussed here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, I do.
Have you ever been treated for mental or emotional illness?
No,
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
understood.
All right. What plea do you wish to enter at this time?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence is adjudication and time served with an order not to return to the CVS at 1700 Southeast 17th Street. And I'm making a note that I told you that.
Okay.
Okay. All right, the Spanish interpreter is here, and when Mr. Egner is in the room, please let me know, okay?
He's here, Judge. I just need a chance to speak to him.
As soon as you're ready, let me know.
Thank you, Judge.
All right, but
Señor,
Mr.
con el español.
Mr.
Señor.
Quiroga,
He's approaching, Judge. He's here, man.
all right, this is Edward Quiroga.
This is Edward Quiroga.
Mr. Quiroga, you're before the court for out-of-state felony hold.
Señor Quiroga, usted está ante este tribunal porque usted tiene una orden de captura desde fuera del estado por felonía.
It is a no bond hold for the state of Georgia.
No hay posibilidad de fianza en este caso. La orden es del estado de Georgia.
And you will be going to the extradition judge next week.
Y usted comparecerá ante la jueza de extradiciones la próxima semana.
Okay? All right, Maria Cardoso.
I'm sorry, Judge. Who else did you want?
Maria Cardozo. Did she also need a Spanish interpreter? Yeah,
North Broward, Judge.
North Broward, okay. All right, Ms. Cardozo, you are before the court today. Charge 1 is touch or strike battery domestic.
Señora Cardoso, usted está ante este tribunal hoy acusada de lesiones mediante toque o golpe en categoría de violencia doméstica.
Number 2 is aggravated battery with a deadly weapon,
El segundo
domestic.
cargo es lesiones agravadas con un arma mortal.
The court finds probable cause.
Consideramos que existen indicios probables.
State, does Ms. Cardoza have any prior criminal history?
Fiscalía tiene antecedentes la señora Cardoso.
She does not that I can see, Judge.
No que yo pueda ver, su señoría.
Based on the allegations, state would ask for no victim contact as well as no return to the incident location.
Con base en lo que se alega en la denuncia, la fiscalía solicitaría que se le prohíba el contacto con la supuesta víctima y que no pueda regresar tampoco al sitio de los hechos.
State would also ask for a $1,000 bond on count 1 and a $5,000 bond on count 2.
Así como una fianza de $1,000 por el primer cargo y $5,000 para el segundo.
And that's based on the nature of the offense and the weapons used and the injuries to the victim in the case.
Dada la naturaleza de, el cargo y las armas utilizadas contra la supuesta víctima en este caso.
All right,
I unfortunately, Judge, because of the language barrier, I was really not able to get any information from Ms. Cardozo.
Lamentablemente, señora juez, habla el abogado defensor, debido al hecho de que a la barrera del idioma realmente no pude obtener mayor información de parte de la señora Cardoso.
So I don't know about what arrangements can be made if the court was inclined to impose a no-contact order.
Así que no sé cuál sería la forma de coordinar si su señoría impone una orden de no mantener contacto.
All right.
Go ahead. Go ahead, Judge.
Proceda.
all right, Ms. Cardozo,
Bien, señora Cardoso,
you will have to stay away from Roberto Pinheiro
usted deberá mantenerse alejada de Roberto Piñeiro
until that order is lifted.
hasta que la orden sea anulada.
You both can't be living together.
Ustedes no pueden vivir juntos.
So, do you have somewhere else to go?
¿Tiene otro lugar donde ir?
Excuse me.
Go ahead.
Proceda.
La propiedad hace 2 años está paga de forma completa y es mía. Roberto Piñeiro no vive en esa propiedad. Yo estoy llena de golpes de Roberto Piñeiro porque de todas formas él quiere.
Ask her to not discuss the facts of the
No,
case.
señora, dice su abogado defensor que no, o sea, absténgase de referirse a los hechos del caso,
But to listen carefully to the judge's questions
pero escuche con cuidado las preguntas que le hace la jueza
and answer those
y
questions.
conteste únicamente lo que la jueza le está preguntando. Your Honor, to interpret what she said the property has been owned by me, free and clear, for since 2 years ago, and Roberto Piñeiro does not live on that property. My forearms are full of bruises from blows that Roberto Piñeiro has struck against me, and at that point she got cut off.
Okay. Ms. Cardoso, if Mr. Pinero does not live there, that's fine.
Señora Cardoso, si el señor Piñeiro no vive ahí, entonces no hay problema.
But I don't have any control over Mr. Pinero at this time,
Pero yo no tengo ningún control sobre lo que haga el señor Piñeiro en este momento.
which is why I have to tell you no victim contact.
Y por esa razón yo debo decirle a usted que se le prohíbe tener contacto con la supuesta víctima.
Do you understand that, ma'am?
¿Entiende?
Encantado.
Yes.
Okay. The next thing is, are you employed?
La otra pregunta es, ¿usted tiene empleo?
Hace 12 años soy jefa de un departamento de una clínica de masaje terapéutico.
For the last 12 years, I've been the head of a department in therapeutic massage clinic.
Okay. And so, how much bond do you believe that you can afford?
¿Qué monto piensa usted que podría costear si tuviera que pagar una fianza?
No tengo idea, yo soy viuda, vivo de lo que trabajo, vivo sola.
I have no idea. I'm a widow. I live off of a salary. I live by myself.
But she owns her house.
Pero usted es dueña de su casa.
Correcto.
Correct.
All right. I am at this time going to impose $1,000 bond on one
Bien, en este momento voy a imponer una fianza de $1,000 para el primer cargo
and a $2,500 bond on two.
y $2,500 para el segundo.
No victim contact,
Se le prohíbe tener contacto con la supuesta víctima
and as I explained before,
y como lo expliqué anteriormente,
that means no phone calls,
eso significa no poder hacer llamadas
no text
telefónicas,
messages,
ni tampoco mensajes de texto,
no social media,
ni mensajes por red social,
no third-party contact.
ni tampoco contacto mediante terceros.
And since it's her home,
Y dado el hecho de que es su casa,
I believe that there was a request for no return, so
Creo
I'll deny
que-
that at this time.
creo que... Deny, Your Honor?
Yes.
Creo que la fiscalía había solicitado que se le prohibiera regresar al sitio de los hechos, dado el hecho de que el sitio del incidente es la casa de su propiedad, entonces voy a denegar esa solicitud de la fiscalía en
Fui
este
yo
momento.
quien llamó al 911, fui yo porque estaba siendo agredida.
I was the
No
one
fue
who
el
called.
señor, fui yo.
Again, I would caution Ms. Cardozo not to discuss the facts of her case.
Nuevamente, señora Cardoso, de parte de su abogado defensor, por favor, no hable sobre los hechos del caso.
Today is not the day of her trial.
Este no es el día de su juicio.
Our main concern today is trying to get her out of jail.
Nuestra principal prioridad hoy es lograr excarcelarla.
And if there's someone who I can call to help her post her bond, I will be more than happy to do that.
Y si hay alguien a quien yo pueda llamar para ayudar a que esa persona pueda ayudar a pagar su fianza, con todo gusto lo hago.
Yo puedo, yo soy sola, pero los oficiales no me permitieron sacar ninguna tarjeta, nada de mi casa.
I can do it myself. I live by myself, but the thing is that the officers didn't allow me.
All right, we're done with we're done at this time.
Bueno, ya.
Okay.
Ya se acabó
Is
este
it-
caso en este momento.
Is there anyone else who needs a Spanish interpreter?
¿Alguna otra persona que necesite interpretar el español?
Judge at Maine,
Okay.
they brought in Mr. Miguel Carrillo Lopez, and he requires a Spanish interpreter on page 15 of the docket.
And in the abundance of caution, Judge, I'm going to ask the court to sign a photo order on Ms. Cardozo.
Sure. All right. What's this gentleman's name again?
¿Cómo se llama este caballero?
Miguel Carrillo on page 15.
Okay.
It's Carrillo Lopez.
Okay. All right. Miguel Carrillo Lopez.
Y el Miguel Carrillo López.
Mr. Lopez is before the court. Charge one is a misdemeanor KPS.
El señor López se encuentra ante este tribunal. El primer cargo es una orden de captura en grado de contravención.
All right. This KPS was issued May 16th of 2019.
Esta orden de captura se emitió el 16 de mayo del 2019.
Mr. Lopez did not show up for a hearing,
El señor López no se presentó para una audiencia
and the charge is DUI, a level greater than .15.
y el cargo es conducir bajo la influencia del alcohol a un nivel mayor a 0,15,
And so that judge issued a no bond hold KPS.
por lo que ese juez o jueza emitió una orden de captura sin posibilidad de fianza.
And then number two is an immigration hold.
El segundo cargo es una orden de detención de parte de las autoridades migratorias
It is a no bond hold placed by Department of Homeland Security.
y es una orden de captura emitida por el Departamento de Homeland Security. No hay posibilidad de fianza tampoco.
And so Mr. Lopez will have to appear before an immigration judge.
Así que el señor López tendrá que comparecer ante un juez migratorio.
And as to the misdemeanor KPS, he has scored on September 9th.
Con respecto a la orden de captura por contravención, el scored on
September 9th?
el puntaje se ingresó el 9 de septiembre.
All right. Is there anyone else who needs a Spanish interpreter?
¿Alguien más?
¿Alguien solamente habla español? No one else at Maine, Judge.
All right, thank you.
And Judge, we're ready to proceed on Mr. George Egner on page 21. Mr. Egner? come
All
on up,
right,
please.
George David Egner. All right, Mr. Egner is before the court. Charge one is battery on an officer or firefighter. And I find probable cause. EGNER on page 21. All right. Does Mr. Egner have any prior criminal history?
He does, Judge. He has a 2017 burglary of a structure and a petty theft for which he received adjudication, 2017 and 2014 thefts for which he received an adjudication, 2013 petty theft, as well as battery and possession of a Schedule 4 substance. All of those were adjudicated, as well as a 2012 grand theft adjudication. Judge, based on the nature of the offenses, as well as his prior criminal history, state would ask for a $5,000 bond.
Okay.
Judge, Mr. Egner's not in a financial position to post a $5,000 bond. He's been here for about 20 years in our community. He's 53 years old. He does have prior contact with the criminal justice system, but as you heard, not extensive. Right now, unfortunately, he's homeless. He's financially indigent. He is applied for a disability. He's waiting to receive disability, so he has no sort of financial income. He has no sort of assets. He has no money in the bank. He owns no property or anything like that. From what he advised me, there's really nobody that can help post his monetary bond. Mr. Egner did advise me he has health issues, Judge, and he is asking for the court to consider releasing him on pretrial release, and he will be coming back to face these allegations, Judge. And also, I'm going to ask the court to sign an order so we could photograph the injuries, the extensive injuries that Mr. Egner received as a result of this incident.
Judge, with regards to that last statement, I believe the officer in the probable cause affidavit asked with regards to the injuries, and he stated that many of the injuries that he received were sustained when he was hit by a vehicle the previous day, as well as the fact that he was struggling in his wrist constraints, which caused him to bleed, and that was after he was placed in the restraints because he spit in the medical technician's face. But I have no objection to a photograph order. Just an objection to how
No,
counsel stated
I'll
it.
sign the order. I was just looking back at the probable cause affidavit because I thought I did see that there. He was actually en route to the hospital with a paramedic when he got up and spit in the paramedic's face. That's what he did. And then that's what the allegations are. And then while he was in hand restraints, it said that he was combative and irate, and that he started, he began scratching at a scab on his left forearm or wrist and was sliding the hand restraint over it. In doing so, Egner causing the scab to bleed, and repeatedly stated that the voices in my head are telling me to do it. So while he was handcuffed to the hospital bed, he began punching himself repeatedly in the face with his uncuffed right hand.
Judge, I would also point out, as relayed to me by the law enforcement officer present, the firefighter did end up sustaining a broken wrist as a result of the defendant's flailing and combativeness in the back of the ambulance.
All right. So based on these allegations, this time I am going to impose a $5,000 bond on this case. Okay? And I will sign that order. All right. Vladimir Matthew. I have, is this for Mr. McLawrence?
Mr. Vladimir Matthew is approaching,
I
Judge.
have those, thank you. All right, Mr. Matthews before the court on a traffic KPS this morning. 10, thank you. This is on a KPS that was issued June 27th of 2017. And the charge is making false affidavit for a driver's license. So I find probable cause.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Matthews' father to post his monetary bond.
All right, here's a $500 bond. All right. Kirby Oxgenor.
I believe North Broward.
Oh, Joe's calling.
So Mr. Oxenor would like to resolve this matter today if possible, Judge.
All right, Mr. Oxenor is before the court on one charge of possession of cannabis, 20 grams or less. And I find probable cause for this charge.
Your Honor, he's currently on pretrial for grand theft auto and criminal mischief in case number 18011-018 CF10A. Pretrial is asking that you revoke his pretrial. He was placed down by his division judge, Judge Fine, on November 20th of 2018.
Has there been any other, any prior violations?
He's had a couple times where he failed to appear, but other than that, no actual violations. No actual warrants were generated.
Okay.
Judge, I'd ask you not to take any action on the pretrial release situation that Mr. Oxenor is in. I know that cannabis is illegal in the state of Florida. It's not illegal in every state, and I'm not condoning anything, but I don't think
We can only go
that.
by the laws in our state.
I know what our oaths are, Judge, and I know, I understand that, but, I just ask you not to take any action regarding this pretrial release conditions at this point, and I'd ask you to consider, if his other prior criminal history isn't too extensive, to consider releasing him on his own recognizance. I didn't hear anything about him not showing up to court while he's been on pretrial release or committing any other type of violations.
All right, so is, are we changing that, he doesn't want to resolve the case because he has a pending felony matter? Is that-
Yeah, I was not aware of that when I spoke with him earlier this morning, but now that that has come to light, I think it's probably in his best interest not to enter a plea at this point. I don't know how that could affect the other pending charge. So I would, again, ask the court to consider releasing him on his own recognizance.
What date did you say that he was placed on pretrial again?
November 20th of
Of
last year.
2018? So we're almost a year. Well, I won't take any action on the pretrial, but I am going to leave a $100 bond in place on this new arrest.
I'll
Okay?
call your mom, Kirby, and see if she can come and help you get bonded out of jail, okay?
Yes, sir.
Okay.
All right, David Blue?
North Broward, Your Honor.
All right, Mr. Blue is before the court for a touch or strike battery. And I find probable cause. Does Mr. Blue have any prior criminal history?
Not that,
Yes, he does.
yes, he does, Judge. He's got a 2000, it looks like a, no, is it 19? That's a 1990 possession of cocaine and drug paraphernalia, adjudication was withheld. Looks like he's got also a 99 possession of cocaine, possession of drug paraphernalia, adjudicated guilty. He also has, he's got a 2006 Bat Leo, for which he received an adjudication. Oh, and I'm sorry, and Judge, that 2006 case was out of felony mental health court. Can you see what the 2013 one is? Oh. And looks like he has a he had a 2013 battery on a person over 65, but he was found unable to stand trial due to mental health issues.
All right, and it seems this probable cause affidavit looks like It was. He said he pushed the victim because the victim was blocking the doorway, and then the victim retaliated by punching defendant multiple times. ILRR, Mr. Blue, at this time.
Judge, I would just ask that there
And,
be no victim contact.
Mr. Blue, can you hear me, sir?
Yes.
All right, so I'm gonna release you on your own recognizance at this time, based on the nature of the allegations. But I'm also going to tell you that you can have no contact with the alleged victim at this time. Do you understand that, sir?
Yeah, so I'd rather not find out right now until further notice.
Okay, well, you don't have to post a bond, okay?
Right.
All right,
All right, thank you. I go back, please.
all right. No. Mr. McLaurin? Good morning. Oh, just a moment. Since we have short hands over here on Fridays.
It's 3. And 3 and 11.
All right, on page 3, Katrina Major,
She's over in North Broward, Judge.
okay?
And Judge, I do want to let the court know that the way that the docket read, I thought she had a separate Broward County ordinance, but I looked on the clerk's website, and it looks like both counts are charged under the same case number, which is going to be a state case number. Yes.
One's a municipal
It's 2
ordinance.
case numbers? Okay.
Yeah. So she has a trespassing and then the other one,
It's an open container, Judge.
yeah, even though, yeah, I see. All right, so I find probable cause.
Judge, I spoke with Ms. Major. I had some concerns about the probable cause in this case because she was arrested along with her co-defendant, Willie James Covington. And they were both charged with open container essentially for the same item. Nonetheless, Judge,
Are you sure? I thought there was one that he said, this is mine, and the other one is hers.
right, so it's beer, and they claim that the beer in the bottle and the beer that was in the cup, that was in the cup holder, is somehow different. In any event, Judge, I spoke to Ms. Covington. I told her that Ms. Major, and I told her that we have this defense. If she wanted to go forward, she told me no, it's okay. She just wants to resolve this matter.
Okay,
Judge, I don't see any priors
okay.
that would necessarily prevent her from taking part in one of the state's diversion programs as far as the misdemeanor charge if she wanted to do that.
I didn't know her prior, so I didn't discuss that with her, Judge.
Oh,
It otherwise seems like she would qualify.
all right, you want to
So-
talk to her about that, Mr. McLaurin?
Sure. Do you want to do Mr. Covington in the meantime, Judge, or you want me to come
It's
back?
up to you.
Okay, I'll come back.
Okay. Ms. Major, yes, go answer the phone.
Okay.
session for magistrates on Thursday. So. You're voluntelling me? I'm being voluntold?
All right, we can come back to this. Is Ori Halber at the main jail? Ori Halber?
Halbert, North Broward. It says North Broward, Jonathan.
All right. So Mr. Halber is before the court on a misdemeanor KPS.
Good morning, Your Honor.
Good morning, Mr. Halber, and this is a case from Judge Lerner Ren's division. She issued this KPS on August 28th because there was a non-compliance with conditional release, and she issued a no bond hold. So I am going to leave that in place, and Mr. Halber, you'll see Judge Lerner Ren on, is that Monday, September 9th, at 9 a.m., okay?
Okay, Your Honor.
All right, sir. All right, and then we can go back to Katrina Major. All right,
Judge, in speaking with Ms. Major, she indicated to me that she would just like to resolve this case.
all right. All right, so if Ms. Major wishes,
To that end, I was going to ask if the court would withhold and somehow give her some, a reduced cost, court costs if the court can, or allow her to do, community service to pay off the court costs or waive court costs.
all right, I will sentence Ms. Major to withhold adjudication and court costs. Do you wish to accept that, ma'am? You wish to accept that? I'm sorry?
What you say? I'm sorry.
Do you wish to accept the offer to resolve your case?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down, and do you understand everything that has been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making a decision?
No.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter at this time? Guilty or no contest?
No contest means that, you're not pleading, you're not saying you're guilty, you're not saying you're not guilty, you're just saying you want to resolve your case here today.
Yes. No contest.
All right, so accept your no contest plea. I find that it's freely and voluntarily given. I'll sentence you to a withhold adjudication, and I'll waive the court costs. Okay?
Thank you.
All right, Willie Covington.
He's in the main jail, Judge. Oh, page 11.
He's approaching, Judge. Come on up, Mr. Covington. He's approaching, Judge.
All right, Mr. Covington, you're before the court on a trespassing unoccupied structure conveyance charge and a county ordinance charge. I find probable cause. What does Mr. Covington want to do?
Judge, he would like to resolve these matters.
All right. All right, Mr. Covington, I guess like your co-arrestee, I'll sentence you to withhold adjudication, court costs. Do you wish to accept that, sir?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down and do you understand everything that has been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am. I understand.
All right, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And
No,
do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
yes.
What plea do you wish to enter, Mr. Covington?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves a withhold adjudication court cost. Good luck, sir.
Thank you, Judge.
You're welcome. Justin Bass? I didn't say, no, it's just court costs. Yeah, 6 months. Justin Bass?
Bass is here present, Judge?
Mr. Bass is before the court on a traffic KPS for a driving while license suspended charge. And back in December of 2016, you did not show up for your arraignment, so that's why you're here today. I don't know if since then you've fixed your driver's license?
Judge, he's state sentenced. He's been in custody all this time. His
Okay.
EOS date is this Sunday, so he's asking the court to consider resolving this case.
Okay. All right. State, is there an offer for Mr. Bass?
Judge, if he wants to resolve it, it'd be an adjudication court cost.
Okay.
Sir? Yes. He wishes to accept the state's offer, Judge.
All right, Mr. Bass, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest, Your Honor.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served. Good luck, sir.
Good luck, sir.
All right, Jason Reese.
Mr. Reese, come on up, please. He's your person, Judge.
All right, Mr. Reese is before the court on a petty theft charge. And I find probable cause.
Judge, in speaking with Mr. Reese earlier today, he wishes to resolve the matter.
Yes, ma'am.
All right, does the state have an offer for Mr. Reese?
Just a moment, Judge.
Sure.
He's got a failure to reply. Failure to report. Is it outstanding? No. Okay. Just one moment, Judge, I apologize. Judge, it looks like he currently has a case pending before Judge Merrigan in case 1900853 Looks like it is a possession of oxycodone. And a 2015 prior cannabis and drug paraphernalia he received a withhold. So at this time, I'm not really willing to resolve the case without knowing more and speaking to.
Well, he may not want to resolve it since he's got a pending felony charge also.
Let me ask him one question, Judge.
How old is that case before Judge Merrigan?
Judge, the date of incident was July 6, 2019.
It's a filed case?
It looks to be, I think they may still be, let me check. I think they may still be waiting on the
Test?
on the testing, which they are. It was a possession of oxycodone, resisting officer without violence, and looks like there was a municipal ordinance violation for an open container.
All right.
Judge, Mr. Reese, we just talked about that. He hasn't gone to court. I think I overheard the prosecutor's conversation, and he said it's not filed. Judge, Mr. Reese still wishes to resolve the matter. From what I heard, as far as the state discussing his priors, I don't believe he has nothing theft related. Considering this is a misdemeanor, Judge, would the court consider extending an offer of a withhold, taking judicial notice of time served, Judge?
Does he have any prior theft charges?
Judge, he does, it looks like he has, there's something out of, from Leland Grove Police Department, that's out of state. Looks like there was a burglary, in 97, a robbery, in Rockford from 93, trespass, resisting disorderly conduct, if this is in fact the same individual.
I believe, Judge, Mr. Reese is not denying it. It was about 20 years ago.
Yeah.
I told him not to get into the facts. My understanding, Judge, from what he's wanting me to express to the court, it was, my understanding is food.
I was hungry. I'm sorry.
Judge, he's asking me again if the court would consider resolving.
Once again, Judge, the question was whether or not he had any prior theft charges, and he does. There's a 1999 simple battery and criminal mischief. There's a 2001 petty theft. There is a 97 trespass, resisting disorderly conduct and burglary, a 93 robbery. There is also a 91 assault, which I won't get into additional facts of that case. There is also a failure to report or failure to comply.
Just considering certainly then would the court be willing to offer time served?
Well, I'm not going to extend an offer at this time. I will leave his bond at $100. He does have a pending charge, and
Would the court then considering, I know he's out on a case, but it's nonviolent, it's food item, would the court consider releasing him under supervision with pretrial?
did he post a bond on that July case?
Let me check here.
Judge, I believe a friend of his did, and that individual, I believe, moved, so that possibility or that door is closed at this time.
Judge, it looks like he is out. There was a $1,000 bond that was posted through a surety on count one. The other counts were no charge on the bond.
Right. So what I have before me is that Mr. Reese is out on bond in July, and now September 5th. And, and I understand, he's saying it's food, but it's just another, I'll release him to pretrial supervision. And Mr. Reese, you need to show up on Monday morning. If you don't show up, or if you get out early enough today that you can go over there, if you don't show up, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am. I barely heard you breaking up a little bit, but if I understood right, you said there'd be a warrant issue for my arrest if I don't show up for this.
That's correct.
We're breaking up some.
All right.
I hear all of it.
All right. Sylvanie Belias.
Mr. Bellius is here, Judge. That man, come on up, Mr. Bellius. And Judge, he did advise me he's going to be hiring his own attorney, so he declined to serve as a public defender.
All right, Mr. Bellius, is it correct you will be hiring private counsel?
Yeah.
And that today you don't need the services of the public defender's office?
No, I don't.
All right, you're before the court today. Charge 1 is resisting officer without violence. Number 2 is loitering or prowling. and the court, I find probable cause. Does Mr.
Repeat
Bellius,
that. I didn't hear you, madam. Can you repeat that?
you're before the court for charge one, resisting without violence, resisting officer without violence. Did you hear that?
Yes, I did.
And number two is loitering or prowling. Did you hear that?
Yes, I did.
And I find probable cause. Did you hear that?
Yes, I did.
All right, and so, does Mr. Bellius have any prior criminal history?
He does not, Judge. State would not object to the standard bond, or if the court would release him pretrial, that's fine.
Okay. Mr. Bellius, do you want to post, can you afford to post your $100 bond?
Yes, but I'm not gonna pay that.
So what does that mean?
Because I don't feel like I'm guilty of any of those charges.
Well, today's not the day to argue or deny your guilt. Today is to just determine if there is probable cause and release conditions. And so you do have the option that you could be on pretrial supervision, or you can pay a $100 bond. So, what do you want to do today?
Pre-trial supervision.
All right. Oh. So RR you to pretrial, and you, sir, you have to follow the rules over there. Do you understand that, sir?
Yes, sir. Yes, Judge.
All right. And you need to make sure that you report to the pretrial office. If you can't make it in time today by Monday morning and failure to do so, a warrant will be issued for your arrest. Do you understand that?
I do understand that fully.
Okay. All right, sir. Corey West.
Mr. West is approaching us. He's here at Maine.
All right, Mr. West, you're before the court on a traffic KPS, and this KPS was issued January 22nd of this year because you did not show up for arraignment on a charge of operating without a valid license. All right, so I find probable cause. You have court on Monday before your division judge.
He wishes to resolve the matter today.
All right, is there an offer for Mr. West?
Judge's offer to resolve would be an adjudication, time served.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. West, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand everything, the offer that has been extended to you today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time, Mr. West?
No contest.
I accept your no contest plea. You find that it's freely and voluntarily given. Your sentence serves adjudication and time served. Okay, Henry Davis.
Mr. Davis is approaching, Judge. He's here at Maine.
All right, Mr. Davis is before the court on one charge of trespassing on occupied structure or conveyance. I find probable cause.
Judge, in speaking Mr. Davis, we're going to be requesting the court consider an ROR on his behalf. He is looking forward to coming back to court and having his day in court on this allegation. Now, he's been here his whole entire life. He's 41 years old. He's working. He worked for a restaurant called Lou's Restaurant. He's a chef there. He's been there employed for 4 months. He doesn't want to risk losing his job. He lives locally here in Pompano Beach. Judge, considering this is a nonviolent charge, he's asking to be released ROR.
Have several priors. However, the most recent was a 2014 resisting without violence and loitering and prowling adjudication, 2014 grand theft adjudication, a 2014 delivery of cocaine, possession of cocaine, unlawful use of false name, all adjudicated. And going back to 2000 and prior, there's a lot of possessions of cocaine. And I think even as far back as, I think 94, there was a kidnapping, robbery with firearm with a VOP adjudication.
All right, his other two co-defendants are also on this docket today. We probably addressed one before. He was not the driver, though the vehicle was stolen. And so I will release Mr. Davis to pretrial supervision. Mr. Davis, you need to report to the pretrial office. If you cannot make it in time today, you must make sure that Monday morning you show up and sign up. Do you understand that, sir?
Yes, ma'am.
All right. Michael Cooper.
Mr. Cooper is approaching, Judge.
All right, and Mr. Cooper is before the court. He's a co-arrestee with the with Mr. Davis, and his charge is trespassing on occupied structure or conveyance, and I find probable cause.
Judge, at this time, oh, I'm sorry.
Pretrial is standing. Yes.
He was placed on pretrial on August 24th by Judge Port and never reported. Pretrial is asking that you revoke his pretrial in case number 19010276 CF10A for a petty theft. Second. Sorry.
And, I'm
Every
sorry.
Friday.
Got it.
And Judge, I would also make note, it seems like he is also on bond or pretrial release before Judge Marina Garcia Wood for a felony petty theft in case number 190102118 CF10A as well. And he also has an extensive list of priors, including possession of cocaine, 2017, 2 counts of felony petty theft adjudicated in a VOP in 2017, 2 counts of grand theft and 2 counts of petty theft in 2017, all adjudicated with a VOP, 2 other counts of grand theft in 2017 as well, petty theft with a VOP, grand theft with a VOP in 2017, 2016, 2 counts grand theft, VOP, going all the way back to 2015 with at least 2 more counts of grand theft and 1 count of petty theft.
All right, so Mr. Cooper, with that prior criminal history, you got the benefit of going to pretrial just August 24th of this year. You didn't even bother to show up. So I am going to grant pretrial's request and revoke your pretrial. This is a felony charge. I am going to impose a $1,500 bond. 19010276 CF10A. And then on this new arrest for a trespassing charge, I'll leave the bond at $25. Okay? Lonnie Aristide. Or Mr. Aristide is before the court. These are add charges, number 6 and 7. Number 6 is fraud, use or possessing ID of another person without consent. Number 7 is a felony violation of probation. It's like you're on probation before Judge Merrigan, which has a no bond hold. And you'll see Judge Merrigan on Monday at 8:30. I find probable cause, and I'll leave the standard bond on 6 in place. Okay? All right. Winston Stewart. All right. Mr. Stewart is on the docket twice. I think it's towards the end. I don't know what page.
And heroin.
These are the end
He's
for
also on-
perfection.
Right.
He's also on for.
And then he's
VOP.
got also a VOP. All right.
Okay.
So, does the state have additional information?
Yes, Your Honor, one second.
Judge, we do have the, we actually have the instruction to the clerk for the filing of the delivery of sale or fentanyl. It was filed on. We also have the BSO Crime Laboratory Analyst report that indicates that the drugs that were found and tested was actually fentanyl, as well as a copy of the information that was filed with the clerk of court showing for 1 count of delivery of fentanyl.
Hold on one second.
Sure.
I've reviewed the lab report, Your Honor.
Okay,
I do not have a further probable cause argument to make at this time.
okay.
Although I do find it somewhat troubling that this information was filed on July 8th and we're only being presented with the lab reports today.
All right, so based on this additional information, I find probable cause for
The actual was 948,
distributing
right?
or delivering fentanyl. And how much bond did he have on, well, there's a $3,500 bond.
Right.
And I'm going to leave that in place. And Mr. Stewart also has a violation of felony probation, which is a no bond hold before Judge Lynch. I don't know when he's gonna see Judge Lynch. I don't have that information, okay?
I don't see a date either, Judge.
Okay. All right. All right, Courtney King.
Yeah.
Please approach the judge's hearing. Brian, can you pick up the phone?
All right, Mr. King is before the court. Charge 1 is possession of cocaine. Number 2 is a felony violation of probation, which has a no bond hold. And Mr. King will be going before Judge Yuson, it looks like, on Monday at 8:30. So I find probable cause. He has a $1,000 bond on 1, okay?
Because.
Michael Habersham,
Yeah.
Mr. Habersham, medical loan, Judge.
medical loan for Mr. Habersham.
Right.
Real Lawson.
Did we skip that? Oh,
Please approach.
some of these are bonds.
All right, Mr. Lawson is before the court. The first charge is a misdemeanor capias. Charges 2 and 3 are felony capiases with no bond holds and are not for magistrate. I'm finding probable cause. I will leave those conditions in place. And he will see his division judges, it looks like Monday and Tuesday, he'll be in court next week. Okay? Timothy Pitts.
Mr. Pitts is approaching, Judge.
All right, Mr. Pitts is before the court on a grand theft auto charge, and I find probable cause.
Judge, right now, Mr. Pitts is not in a position to post the standard bond, $1,000, which is currently set. Now, he does have a record, but he advised me he's been about 3 years clean. He's been living in our community for 30-plus years. He's 32 years old. He's working in landscaping. He gets paid when the weather permits, about $90 a day when there's work. He lives in Pompano Beach with his father. His father just recently had a stroke and he is not working, so his father's not in a position to post his monetary bond. So he's asking to be released on pretrial release, so he can be there for his father.
Judge, the only priors I have is a 2006 trespass adjudication and a 2017 possession of cocaine adjudication with the VOP.
Okay.
So I don't have an issue with the standard bond amount or if the court wants to release him to pretrial.
All right, Mr. Pitts, I'll release you to pretrial supervision. You must report to the pretrial office if you can't get there in time today on Monday morning. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
Okay.
Good luck, sir.
Carmen Patterson.
I've been advised he bonded, Judge.
All right, Mr. Patterson bonded. And so next we have Travoy Flores.
He's approaching, Judge, here at me. Come on up, sir.
All right, Mr. Flores is before the court. His 2 counts of false report, bomb, explosive weapon, mass destruction, and number 2, intimidating, right, send, or threat to kill or injure.
Your Honor, there's a 2013 failure to return leased property for which he received an adjudication. And based on the nature of the offenses, Judge, State would request a $2,500 bond on each count. Or if the court is inclined to give pretrial, the state would also ask for a GPS monitor. No contact with the victims by any means.
Okay.
Judge, as you heard, Mr. Flores has very little contact. 8 years old, been here his whole entire life. He's going to school. He goes to South Broward High School. He's a junior. He goes from 7 in the morning to about 2:40 in the afternoon. He lives in Hollywood with his grandmother, and he lives there also with his 3 younger siblings. My understanding is his grandmother receives disability, and she's not in a position to post his monetary bond. He has no money in the bank, no sort of property. We don't object as far as what the state's asking as far as their special conditions, but he doesn't have the financial resource to post any sort of monetary bond. We're going to be asking the court if the court would consider releasing him under level 2 supervision with a monitor, so he could be supervised. We can know where he is, but right now he can't afford to post any sort of monetary bond.
I think I probably said this yesterday, or maybe I've said it before, but just in this day and age that we live in, I don't know why people continue to send text messages of this nature. But Mr. Flores has has a limited prior criminal history. I will release him to the level 2 pretrial supervision. Mr. Flores, there shall be no phone calls, no text messaging, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right, and no victim contact. Do you attend school with these people?
My understanding, they do not attend school, Judge.
All right, so then no contact. All right. Okay, sir.
Thank you.
You'll hear from pretrial. Breon Atwell.
He's approaching, Judge. Your name?
Mr. Atwell is before the court. Charge 1 is possessing structure or conveyance known for drug trafficking. Number 2 is possession of a weapon or ammo by a convicted felon. Number 3 is trafficking in MDMA. Number 4, trafficking in heroin. Number 5, possession of drug paraphernalia. Number 6, distribute, deliver cocaine. Number 7, distribute, deliver heroin. All right, the court finds probable cause. And I'll hear from the parties in regards to bonds and prior criminal history.
I have a 2017 possession of cannabis withhold, a 2013 attempted burg dwelling and a resisting without violence adjudication, a 2013 ag assault deadly weapon adjudication, is that it? Already got that? No. Judge, that's all I have as far as priors go. Judge, I did speak with the detective in this case. The state's going to be asking for a nebia hold, as well as if the defendant is able to post bond, that he be required to have a GPS monitor, be monitored through pretrial. According to the officer, what he relayed to me was that they have had the defendant under surveillance for some time, that they have seen him driving a high model Mercedes for which he uses in drug deals. I believe he stated that they also found about $8,200 in cash on the individual. And the law enforcement officer has pictures and surveillance of the defendant with both the cash and the vehicle in question. The officer relayed to me that the defendant states that, at least to the officers during a post-arrest interview, that he stays with his grandmother, but when the officers contacted the grandmother said that he does not live there and she does not house him there. So for those reasons, Judge, we're asking for the nebia hold, as well as, I think on count 2, the state would ask for a $10,000 bond in addition to the standard bonds that are listed. And any bond that's posted, we would ask that he have a GPS monitor upon his release.
Okay.
Judge, and speaking of Mr. Atwell, my understanding, Judge, is he's been here his whole entire life in South Florida. He's 24 years old. He does have family that resides in our community, specifically his grandmother. His grandmother, from what he advised me, is not in a position to post his monetary bond. Now, he does go back and forth between his grandmother and his girlfriend. His girlfriend lives in Pompano Beach, and my understanding is that's the person he'll be reaching out to help post his monetary bond. She works for a local moving company. Specifically, as to counts 3 and 4, I see the standard bond in place is $75,000, so $150,000. That's something that he advised me he's not in a position to post, nor his girlfriend. From what he did advise me, he works when he can in landscaping, and if there is work, he gets paid $60 a day. The judge specifically as to counts 3 and 4. Mr. Atwell has asked me to request with the court if the court would consider reducing the monetary bond from $75,000 to $10,000 on each count, Judge. And as you heard, as far as his prior contact with criminal justice system, the last time he had any contact was basically back in 2013, besides the misdemeanor cannabis. So he's been clean for almost about, my math is correct, 6 years, Judge.
Judge, I would also point out, the officer did relay to me information with regards to the girlfriend. I believe the officer said that the Mercedes is actually listed in the girlfriend's name, but that the defendant does utilize the vehicle for the drug sales and has been seen and surveillanced dropping the girlfriend off for work and then continuing on to his job of selling the narcotics using the Mercedes.
All right. Based on the allegations that I have, and it seems like, there's conflicting information about the grandmother. She says he doesn't live there. He's saying he's between grandmother and girlfriend. But this was an investigation by the Crime Suppression Unit. And based on the information that I've received today from law enforcement, plus this affidavit to arrest, I am going to impose on 2 and 3, on two, a $10,000 bond. The other standard bonds will remain in place, and this will all be subjected, he'll be on a level 2 pretrial if he posts his bond, and the bond I'm going to require the Nebbia hold for posting his bonds, okay? James Penault. Mr. Penault is before the court on a violation of parole, and it is a no bond hold for Mr. Penault to appear before the parole board, okay? Ruben Edwards.
He's approaching, Judge. Hear me.
All right, Mr. Edwards is before the court, charge 1, burglary, unoccupied dwelling unarmed. Number 2, grand theft. 3, burglary, unoccupied dwelling unarmed. Number 4, grand theft. 5 and 6, burglary, unoccupied dwelling unarmed. Number 7, grand theft. Number 8, burglary, unoccupied dwelling unarmed. And number 9, grand theft. I find probable cause for all these charges. We need to set bond. I'll hear from the parties.
Judge, I would make the court aware that it seems like Mr. Edwards is on bond, excuse me, let me just make sure, that he is out on bond in case 19010-636 CF10A. It is currently an unfiled case before going to be before Judge Siegel, for which he was recently magistrated on Wednesday, August 28th, and the bond was posted, and he was released Monday, September 2nd.
How much bond was posted?
Looks like $2,000, $6,000, $8,000. That was 3 counts of burglary, unoccupied dwelling, unarmed, and 2 counts of grand theft.
Okay.
Judge,
So the incident, hold on just a moment. So that incident date was August 28th, Mr. Berman?
Let me check the incident dates, Judge, because there are
Because I have
couple
I have 4 different ones here.
Correct.
And I just wanted to see.
and I did make sure that those are not the same ones as were presented here today.
Okay. I have a
Looks like the date of those, Judge, were August 20th, 2009. And the ones in the probable cause affidavit that are before Your Honor today, it looks like these were from August 16th, 2009.
19.
19, yeah. I'm sorry, what did I,
You said
2009? Sorry, 2019.
Okay. All right, so today I've got incident dates of August 16th, July 21, July 1st, July 15. Okay? All right. Okay.
Judge, and that's what Mr. Edwards advised me. He advised me that he was here last week. He was magistrated, I believe. This is part of the investigation, similar to what he was here before this court last week, Wednesday. Now, he's 19 years old. He's been here for 4 years. He lives with his mother. His mother is the person that posted his monetary bond. She's a hairstylist. And from what Mr. Edwards advised me, basically his mother has used up all her financial resources to post a monetary bond. Prior to basically this incident, he has no prior contact with the criminal justice system. Right now, Judge, he is signing up at Whittam Rogers in order to obtain his GED. My understanding, Judge, Mr. Edwards cannot afford any sort of monetary bond, neither can his family. Judge, he's asking at this time to consider being released under supervision.
Well, I'm not confident that that's a good idea at this point in time, based on the nature of these charges, the proximity in time. It just seems like it's a downward spiral if he's never been in trouble before. And so, aside from this new arrest, Mr. Berman, are there other priors?
I didn't see anything in Broward County, Judge, and I don't believe there is anything else.
And the nature, the charge from August 28th, what are the nature of those charges?
The prior ones, it was 3 counts of burglary, unoccupied dwelling, unarmed, 3 counts, and 2 counts of grand theft.
So it's the same exact type of charges?
Same charges, yes, Judge. Looks like, Judge, I think just reading the probable cause affidavit from the earlier case, looks like the defendant and whoever was with him attempted to use a cinder block to attempt to shatter the rear sliding glass door of at least one of the homes. The vehicle was captured on surveillance cameras at a second location where a second residence was burglarized, the same vehicle used in both. And it seemed to be the same individuals involved in the same MO and method of entry into the residences. And I believe, also in reading the PC, Judge, it says that the defendant admitted that he and his friends, Mike, J Money, Tyrod, Tony, used his sister-in-law's Kia Soul to burglarize the homes. Admitted he was struggling financially, needed the money to turn the electricity on in his house, committed the burglaries because he was hungry and needed food.
Would the court consider level 2?
No, I am not going to release him to pretrial supervision. These are alarming circumstances. I am going to impose $3,500 on each of the burglary charges, 1, 3, 5, 6, 3,500, and then the other standard bonds will remain in place. Where? And 8. And was he on pretrial on the other?
I don't believe so. I think it was just standard bond that was posted, Judge.
All right, and I am gonna add a level 2 pretrial in addition to the bonds.
I would just ask, Judge, no victim contact and no return to any of the locations.
No victim contact and no return to any of these locations. Do you understand that, Mr. Edwards?
No return.
Yes, say. Return.
Okay. Terrence Benjamin,
Been advised he bonded, Judge?
Frank
Square?
Square?
Like a button. Square like a button.
Square, okay. All right, sir, you're before the court. Charge one is influence, intimidate, or hinder law enforcement duties. And number two is trespassing on a property not structure or conveyance. I find probable cause.
Judge, at this time, I'm going to be asking for a property order.
Okay. All right, he has $1,000 bond on one. And
Do it, sir.
Rashard Berrien.
Mr. Varian Richard is here present. Come on up, sir. Judge, my understanding is he declined the services of public defender. He's going to be hiring his own attorney.
All right, Mr. Berrien, you're before the court this morning. Charge one is resisting officer without violence. Number two is tampering with or fabricating physical evidence. 3 and 4 are felony violation of probation. Those have no bond holds. And so you'll be going before your division judge on September 9th at 8:30. I find probable cause, and I'll leave the bond of $1,000 on charge 2 in place. Okay?
What you say?
You have 2 no bond holds and $1,000 bond on 1 charge.
Oh, that's all I got?
That's all you've got. Kenneth Keefe?
So I go to court on Tuesday?
Yes.
Okay, man.
Monday.
Monday at 8:30, sir. Okay.
Kenneth Keefe.
Mr. Keith is also present here, Judge. My colleague asked, he's declined the service of public defender. Oh, no, this is Mr. Egner. What? What's your name?
Keith, Ken Keith.
Kenneth Keith, I'm sorry, I just want to make sure I was speaking to the correct person, Judge. He declined the service of public defender. He's going to be hiring his own attorney, Judge.
All right, Mr. Keefe, you're before the court for 1 charge of burglary with assault or battery. And I find probable cause. Does Mr. Keefe have any priors?
No.
Judge, I see a 2004 unlawful acquisition of medicinal drugs for which he received a withhold, and that seems to be all I see.
Okay,
That was adjudication withheld.
That's correct. That's what I
all
said.
right. Well, it's interesting that you know the sentence, but when we asked at first, you were quick to say, no, you have no priors.
Well,
Anyway,
I thought that might mean convictions. I apologize.
okay. All right.
I would just like to say that I've never been in trouble for any kind of violence. I was actually punched 4 times before I returned a punch. Okay, I'm sorry.
Sir, are you employed?
Yes, I am.
How much money do you make?
A year or per month?
Either one.
$51,000 per year.
Okay, and who else lives with you?
My girlfriend.
All right. And do you own your home?
No, we rent.
Do you own a car?
I am financing my car.
All right. Well, these are some serious allegations that you're facing at this time. Since you have no violent prior, I'm gonna impose a $2,500 bond. And I'm gonna tell you that you have no contact with the alleged victim in this case. Do you understand that, sir?
I do.
All right.
I would also ask for no contact with the 2 independent witnesses as well.
And no contact with the witnesses also.
I don't even know who they are.
All right. Well, maybe you probably don't want to go back to that location.
Okay.
Maybe that will satisfy that problem. All right? Okay, sir. Antonio Green.
Judge, he's approaching, and Mr. Green declined the service of public defender. He wishes to represent himself.
Okay. All right, Mr. Green, you're before the court. Charge one is aggravated assault with a deadly weapon without intent to kill. Number two is possession of a weapon or ammo by other state felon. Number three is carrying a concealed firearm. I find probable cause. And does Mr. Green have any prior criminal history?
He has a warrant out of Georgia for a battery.
A warrant out of which state?
Georgia, Judge.
Georgia.
Georgia.
He also looks like he had a 2010 possession of cocaine with intent to distribute or sell, received a withhold, but there was also a violation of probation. And looks like a 2010. Do you have this? I can't. Okay. Looks like there was also make, possess, or throw a destructive device. He received a withhold of adjudication for as well, with probation on that case as well.
All right. All right, Mr. Green, is there anything you wish to say in regards to your bond? Don't talk about your case.
Yes, ma'am. I just would. Can you just give me a low bond so I can just get out, ma'am? 'Cause I have to work tonight, and basically that's it. And I haven't been in trouble for 10 years, so hope you just be limited on me.
All right, well, these allegations are alarming, and there's a gun involved, that the allegations are that you pulled a revolver and pointed
can
it
I
at,
say something on
no,
that?
and pointed at the victim's face, and then said, "I'll bust a cap in you, I came here strapped." And so I have cause for concern. I am going to impose a $3,500 bond on one. Same on two. And then you have $1,000 bond on three. And I'm going to tell you, no victim contact. That means you can't call them, you can't write them, you can't text them, you can't make any comments to them on social media, you can't send a third party to have any contacts. Do you understand that, sir?
Yeah.
Okay. Kingston Pierre.
Come on up, sir. Mr. Pierce here, present, Judge of Maine.
Mr. Pierre is before the court. Charge one is unlawful possession of personal ID of another, and number two is extortion. And I find probable cause.
Judge, looks like Mr. Pierre has 2011 resisting without violence, withhold, 2012 burg dwelling and grand theft, both adjudicated with a violation of probation. 4 counts of petty theft from 2018, all adjudicated. A trespass and petty theft, all adjudicated from 2018 as well, prior to this incident.
Okay.
Judge, based on the defendant's criminal history and the nature of the allegations, state would ask for a $5,000 bond on count 2, and that would be it. We'll leave the standard bond in place on the misdemeanor, Judge.
Okay.
Judge, this being Mr. Pierre, he's been here his whole entire life. He's working. He works for a company called AMS Trucking. He's been there for about a year and a half, making $8.50 an hour. Now he lives in Margate. He rents a room. He's been renting a room there for the past 5 years. He pays about $500 a month. He uses that to basically his wages to pay for rent, and also he is a father to help support his daughter. Now, from what he advised me, there's really no one that can help post his monetary bond. Judge, he's asking to be released under supervision with pretrial release, Judge.
I am gonna deny that. I am going to impose a $5,000 bond on 2. No victim contact. Okay. Taurus Horn,
What is a medical reset, y'all?
the horn is a medical reset. Mario Surpris,
Yeah.
he's been released. The immigration, okay. She said the immigration hold was dismissed, he's been released. All right, Ernest Montgomery,
Paul Ryan, I believe, Judge?
all right, Mr. Montgomery, this is a change of charge from a burglary occupied dwelling unarmed
Yes.
to burglary unoccupied dwelling unarmed. How much bonds, was he previously on?
5,000.
How much?
5,000.
Okay. All right, so I'll leave the $5,000 bond in place, okay?
I done 32 days in lockup.
All right. Do we know if the information on this case has been filed?
Let me check, Judge.
I done 32 days since the last time I seen it.
Well, that's a conversation you need to have with your attorney, but I was just checking to see if the information has been filed.
Looks like it was filed, Judge, as of August 16th.
All right, so has he had an arraignment yet?
Yes, it is.
Oh, okay, so you've been to court. This is just, this is just a matter of procedure. So you already have a division judge and you know who your attorney is. So any other issue, you have to go before your division judge on that, okay?
So there's no way I can get a trial release or anything?
You have to
Division?
you have to go before your division judge, speak to your attorney about that, okay? All right, I believe that we are at the end of our docket, so I will see everyone this afternoon at 1 p.m. All right?